Hello, everyone, and welcome to our latest edition of School Rights Scoop. My name is Patrick Maloney, and I'm a staff attorney with Legal Aid of Western Ohio. Today, I will be discussing Ohio's Supporting Alternatives for Fair Education Act, otherwise known as the SAFE Act. Before we get started, I do have a few ground rules. I'll be providing general legal information about education law in Ohio only. It is not legal advice, and you should not rely on this information for any legal purpose. You should be aware that information regarding any new laws, policies, or interpretations continue to change. The legal information we are providing is current as of March 5th, 2021. If you are seeking legal advice, you should seek out your own attorney. If you need help from an attorney, there is a link in the comments with a map of our legal aid firm's service area. If you live in one of the highlighted counties, you may apply for help by calling the legal aid line at 888-534-1432, or you can apply online at legalaidline.org. If you are viewing this outside of our service area and have a legal issue, there are several legal services law firms throughout Ohio which may cover your area. As I said at the top, today I'm going to be discussing what parents and caregivers need to know about the protections that Ohio's SAFE Act can provide for students. First of all, I'm sure that you're wondering what the SAFE Act is. The SAFE Act was enacted in 2018 as a method to provide additional protections for students in the third grade and below from being removed from the school setting. These protections apply to two kinds of removals: suspensions and expulsions. This act encourages school districts to use positive behavior intervention strategies instead of punishment and works to prevent suspensions for disruptive and nonviolent behavior. For disruptive and nonviolent behavior, school districts are required to limit the use of suspensions and expulsions for students in the third grade and under. These students can still receive in school suspensions, but only if the student remains in a supervised learning environment and they're allowed to complete their assignments for credit. For instance, students cannot simply be removed to a hallway or other unsupervised office area to serve an in school suspension. Students can still receive out of school suspensions and expulsions, but only when the conduct that they engage in affects the safety of classmates, teachers, or other school staff. For the purposes of the SAFE Act, school here includes any school function or school sponsored activity, such as a field trip or sporting event. Conduct that affects the safety includes bringing a gun to school, bringing a knife to school when that knife is capable of causing serious bodily injury, making a bomb threat, engaging in a crime that would cause serious bodily harm if that crime was committed by an adult, and any other act which may cause an immediate threat to the safety of students, teachers, or school staff. If an action that I just listed occurs, a student in the third grade or below can still be suspended or expelled. Any removal of the student from the school is either a suspension or expulsion, even if the school calls it something else, like a cool-off period or a break. If the school wants to suspend a student in the third grade or below, that school must provide written notice of the intent to suspend that student, and that notice must contain the reason for the suspension, as well as describing the process to appeal that suspension. A student must be provided with the opportunity for an informal meeting to challenge that suspension. The process for expelling a student in the third grade or below is similar, but for an expulsion, the school must provide a written notice of intent to expel the student to the student's parent or guardian, and provide the opportunity for a hearing with the superintendent to challenge the expulsion. Before suspending or expelling a covered student, the principal of the school must consult a mental health professional. If that professional determines that mental health services are necessary, then the parent or guardian of the student must be assisted in locating a provider of those mental health services. If you have concerns about the mental health of your child, please ask the school for help or assistance regarding locating these necessary services. If a student is suspended or expelled, a parent or caregiver or guardian can engage in advocacy on behalf of that student. A parent or guardian should review any suspension or expulsion notices to determine the reason for that removal and to learn about any appeal opportunities. A parent or guardian should ask for a meeting with the teacher or principal, ask for a copy of that student's disciplinary records, and ask for written witness statements. It is important to also take notes in any meeting with the school district and bring your own witnesses to any expulsion hearings. It also never hurts to contact your local legal aid organization to find out if any additional assistance is available. Speaking of discussing matters with your school district, as a general rule, parents should document any communication they have with school staff. Some parents keep a journal of communication that includes the date and time, the person they spoke with, and the details of that conversation. Other parents write on a wall calendar or keep a note in a calendar on their phone. Others just send a quick email to the person they just talked to in order to create a written document of the conversation. As a general rule, the process for out of school suspensions and expulsions that I just discussed does not have to be followed in an emergency situation. A student can be removed if that student poses an immediate and ongoing danger or threat to disrupting the academic process, and that danger or threat cannot be eliminated without removing the student. A superintendent, principal, and vice principal can all remove a student when there is an emergency. A teacher may remove a student, but only with permission and from an activity that that teacher controls. After a student in the third grade or below has been removed due to an emergency situation, that student must be given a written notice describing the reason for that removal as soon as practical. Emergency removals cannot be for more than one full school day, and a hearing must be held on the next school day, and the person who ordered or requested the removal must be present at that hearing. A hearing is not required if the student is removed from the school for less than 24 hours. After an emergency removal, a parent or guardian has a few advocacy options. They can request a special education evaluation or a behavior intervention plan if the types of behavior that led to the emergency removal happen with some frequency. These types of evaluations and plans may help addressing any underlying cause for those behaviors. Parents and guardians should also consult with a mental health professional as part of this process. It is also a good idea to contact the student's teacher to discuss an opportunity to make up any missed assignments. In some situations, it might also be appropriate to file a complaint with the State Board of Education regarding the emergency removal process that the school used. This would also be a good opportunity to contact your local legal aid to see if there's any additional assistance available. The protections of the SAFE Act will become fully effective for the 2021 through 2022 school year and will apply to public and charter schools. Private schools are not covered by the SAFE Act. For this current school year, the 2020 to 21 school year, schools can still use out-of-school suspensions and expulsions, but the total number of those suspensions and expulsions for students in the third grade and under needs to be at least 50% less than the previous school year. As I said at the top, this video has provided general legal information about the education law in Ohio only. It's not legal advice, and you should not rely on this information for any legal purpose. You should be aware that information regarding new laws, policies, and interpretations continue to change. The information that I'm providing is current as of March 5th, 2021. If you are seeking legal advice, you should consult your own attorney. Parents with concerns may apply for our assistance by calling the legal aid line at 888-534-1432, or you can apply online at thelegalaidline.org. Thank you for tuning in. Goodbye for now.